So let me start by saying that I'm Daphne Terrace. I'm the Dean of the Ted Rogers School of Management. Thank you everyone who is attending today to learn, to reflect, to hear truth, and Canada's national attempts at reconciliation. Friends from our school, our university, our community, OLMA, the National Academy of Arbitrators, welcome. This university practices land acknowledgement, which emphasizes Indigenous land claims, whether through treaty or historic settlement or current use. This university tries to affirm its obligation to the Anishinaabe, Haudenosaunee, and Mississaugas by calling their names. However, as today's session is larger, encompasses coast-to-coast treatment of First Nations peoples, we are doing a land claim by affirming our responsibility to learn, to hear truth, and to engage in reconciliation efforts, whether individually or collectively or both. We recognize that there is hard work to be done to enhance understandings so that those who are privileged question the truths that they have absorbed all their lives and push many of those truths aside to make room for both knowledge and wisdom needed for reconciliation. It is my pleasure, in fact, my honor today, to introduce our speaker, Daniel Shapiro, who graduated from the College of Law at University of Saskatchewan and has, in his own independent firm, Brayford Shapiro, practiced law since 1982 in Saskatoon, Saskatchewan. His practice focused on civil litigation, and he's an experienced arbitrator, adjudicator, and mediator. He was appointed by Ontario Superior Court to adjudicate hepatitis C class action claims. Since 2003, Daniel has been deeply involved in Indian residential school claims, first as senior adjudicator, and ultimately since 2013 as the Chief Adjudicator for the independent assessment process. You'll hear Daniel and I refer to it as the IAP, that's the independent assessment process of the Indian Residential Schools Adjudication Secretariat. The IAP work concluded with 30,500 individual claims receiving over $3.2 billion in settlements. This was part of the largest class action lawsuit in Canadian history in 2006 that also resulted in the Truth and Reconciliation Commission, as well as many other initiatives. Some of what you hear may be deeply disturbing. There is a residential school survivors crisis hotline at 1-866-925-4419. And if you need it, you can also Google it or ask in the question and answer, and we'll put the number there. I urge you after this event to take time to decompress, because I think you may need it. Now, in terms of running this session, we ask that you use the question and answer tab at the bottom of your Zoom screen. We will not be using the chat function because we need to concentrate on Daniel's words and his experiences. If I don't respond to your question, forgive me, we do anticipate a great many questions throughout the talk, and I'll do the best I can to represent them with Daniel. So Daniel, welcome. Thank you so much for being here. It's very courageous of you. I'd like to start by asking just the simple question, if you could tell us about the background that gave rise to that massive class action lawsuit and how it was dealt with through the residential school settlement agreement and your own independent assessment process. So what's the background to all this?
Thank you very much, Daphne, for the kind introduction and for inviting me to be part of the Ted Rogers School of Management Dean Speaker Series. And to all of you who are participating for taking the time to join in. I am participating today from Saskatoon, located on lands that are on Treaty 6 territory, which is the traditional territory and home of the Cree, Dakota, Saulteaux, and Métis nations. So I'll be happy to talk about the background. Some of this is a bit dense, but I think it helps to inform and situate the settlement agreement that the IEP is a part of, and for people to have a better understanding of how it was created. Having said all that, I will just preface my remarks by pointing out possibly the obvious, that my perspectives are only those of one private citizen, non-Indigenous at that, on the IEP, which I worked on from its inception until its wind up. And I can say that it was a profound, life-changing honor for me to meet and work with so many extraordinary, strong, resilient, wise, and inspirational survivors from all over the country. And also, just by background, just bear in mind that the Secretariat that I led had no involvement in negotiating the settlement agreement itself, of which the IEP is a part. We were responsible for implementing and administering it, and that was assigned to us by the parties and the courts. And we were asked to fairly and neutrally adjudicate the claims. So it really is for history and the parties to the agreement, first and foremost, to say what their expectations were of the IEP and whether those expectations were met or disappointed. But I will start with a high-level view of the historical context, and I hope that will stimulate dialogue on the choices made to address historic wrongs in this case, and also current trends, and thinking about, future issues that will arise. Residential schools started in the 1600s in New France, and they were failed experiments with early stories of abuse. But despite these failures, the so-called modern era of residential schools started in 1883, when the government of Canada formalized a policy to create these residential schools for Indigenous children, establishing 3 schools in Alberta and Saskatchewan. And the residential school system, which was funded by the government but run by the churches, was designed to separate children from their families in order to civilize them, was one of the terms, and to get rid of the Indian problem. And these schools mushroomed to the point that ultimately every province and territory except PEI and New Brunswick were part of the residential school system. And by the time the last residential school closed in 1997, more than 150,000 First Nations, Inuit, and Métis children attended these schools. And so this modern era of residential schools spanned over 100 years and over more than 100 schools. And for most, the experience was profoundly negative and had lasting impacts on children, their families, and their culture. Children as young as 3 were forcibly removed from their families and communities and taken to schools. When they arrived, their clothes were often discarded and destroyed. I can recall hearing from claimants whose it was accustomed to have the students' hair shorn when they arrived at school. And in some cultures, shorn hair, so the long braids were cut and shorn hair symbolized a death in the family. So for many of these students, they were wondering as soon as they got to the school, who from their family had passed away. So very traumatic kinds of experience where students were no longer called their names, often were given new English or French names or numbers by which they were referred to throughout their school years, forbidden to use their language, forbidden to practice their cultural beliefs. And many schools prohibited contact with families. And children didn't see their families for months, and in some cases, years at a time. I did cases in the Arctic where former students spoke about flying for 8 hours to get to a residential school in the Southern Arctic and not seeing their parents for 10 years. And when they came back, they didn't recognize each other, didn't speak each other's language. The students would only eat with utensils. The parents thought they were being disrespectful. So very dramatic impacts on folks. And students faced extreme discipline in the school and were often forced to do the labor to run the school. If they tried to escape, they were tracked down. They were usually tracked down by police, brought back to the school and punished. And of course, the legacy of the schools that we were dealing with, many students were subjected to serious physical, psychological, and sexual abuse. In 1991, Phil Fontaine, who was then the head of the Assembly of Manitoba Chiefs, really stunned the nation with an interview with Barbara Frum on the Journal. And he spoke about the prevalence of abuse at residential schools. And he told her, and I'm quoting, in my grade 3 class, if there were 20 boys, every single one of them would have experienced what I experienced. They would have experienced some form of sexual abuse. And he called for a national inquiry, or an inquiry into residential school abuse. But this was an incredibly courageous act and a singular turning point in bringing residential school abuse into mainstream consciousness of the Canadian public. And then so with that, starting in the 90s and continuing into the 2000s, organizations and individuals started to look for ways, for paths to acknowledge and address the legal, the moral, and the spiritual wrongs that the residential schools legacy had inflicted. And then we saw in 1996, there was a release of a report on the Royal Commission on Aboriginal Peoples, which said that there needed to be a new relationship between Aboriginal and non-Aboriginal people, and they needed to find practical solutions to stubborn problems. And one chapter of that report was devoted to residential schools. So we're seeing a continuum here, nothing jumping out yet, but in 2000, there was a very good starting point in terms of the release of what were called exploratory dialogues. And those involved basically, those were survivors, Canada, and churches meeting to discuss alternative strategies for dealing with residential school claims. The main conclusion was the need to develop additional tools and models to resolve disputes involving school abuse. By 2000 to 2003, we started to see pilot projects, and that involved 12 schools, and it involved private contractors being hired to assist the parties in negotiating a settlement of the claim. But it was limited because the fact finders had no authority to make an award. They couldn't award compensation. But it was a start. In amongst this, in 2002, there was a Kaufman inquiry about abuse arising out of the Nova Scotia School for Girls in Shelburne, Nova Scotia. And in 1996, the government had implemented an alternate dispute resolution claim to try to provide compensation to victims for abuse. But it was reviewed by Judge Kaufman, who found that the program was seriously flawed, so flawed that it left in its wake true victims of abuse, who are now assumed by many to have defrauded the government, innocent employees who were branded as abusers, and a public confused and unenlightened about the extent to which people were or were not abused while in care. And this is important background because it had just been released before the negotiation of the settlement agreement. And it concluded that it was necessary to have a credible valuation process in any dispute resolution model addressing claims for childhood abuse. So the concept of validation was evidently an important one for all of the parties to what ultimately became the settlement agreement. Then there was, between 2003 and 2008, the ADR program that Daphne referred to in your introduction. And this was also a step forward, a significant one. With this process, adjudicators could make awards, and the awards were binding on Canada. claimants were free to accept or reject them. It introduced a plausible link test, a much more relaxed test for proving harms and opportunity loss versus the court tests, which were called the causation tests. And it also introduced the inquisitorial process where adjudicators did all the questioning. In total, there were about 5,000 ADR claims. And
I'm just, because I'm ferocious about use of, people know acronyms, ADR being alternative dispute resolution.
yes, thank you. Yes, sorry, but the alternative dispute resolution process was important for all of the changes. It created the first binding decision-making process, at least binding on the government. And it was really a no-risk proposition for claimants. If they didn't like the decision, they didn't have to accept it. But it was missing some components. The Catholic Church hadn't yet subscribed to it. And so claimants were only entitled to 70% of their award in cases where it was a Catholic school. In Protestant-run schools, they would get 100% of their awards. And there were other problems. There were different levels of compensation depending on where you lived. But it was a big step forward. And it occurred at a time that pragmatically people were realizing litigation was not going to work here. It was too time consuming and beyond the ability of the courts to effectively manage. Even in Saskatchewan alone, there were almost 9,000 claims. And by the time, before the settlement agreement, only 2,200 cases had been settled and only 36 trials had taken place. One trial, and it was admittedly a difficult one, a complicated one, it was called Blackwater versus Plint, involving the Alberni residential school in BC, lasted 115 days, spread out over 3 years. And so the government estimated it would take 53 years to resolve the civil cases at a cost of $2 billion in administration alone. It was also calculated that in civil litigation, it costs $3 in legal and court costs for every dollar paid to former students. So there were too many risks to all people to leave it to litigation to decide. And so there were efforts made to develop a pan-Canadian settlement in the context of many class actions that had started across the country. And that appeared to be the only viable answer as far as moving forward. In 2005, another important date, there was an agreement in principle that was brokered by retired Supreme Court of Canada Judge Frank Iacobucci. And there were, I think, 80 signatories to it, top negotiators in the country on behalf of former students, led by, at that time, National Chief Phil Fontaine on behalf of the AFN, and representatives from the Inuit and numerous top lawyers representing survivors, among others. And the agreement was designed to be holistic, comprehensive. And as Daphne mentioned, it did lead to the largest class action settlement in Canadian history, providing compensation and support for an estimated 80,000 survivors. Just after the agreement in principle, the agreement was the only element of the Kelowna Accord. He was negotiating that. That was the only element of that survived the collapse of the government. And the agreement was ratified by the incoming Stephen Harper government. But it easily could have been otherwise. And then by 2006, thousands of individual legal actions were consolidated into a single class action settlement. And the Indian Residential School Settlement Agreement was approved by superior courts in 9 provinces and territories. So I'll refer to that when I refer to the settlement agreement, that's what I'm referring to. But it was a huge, it was a continuation of significant measures undertaken on the path of towards recognizing and healing the past. 5 major initiatives were part of the settlement. Number 1, and I'm not just saying that because I'm a fan of the IAP, but a secretariat was formed to determine claims brought under the IAP. for sexual and physical abuse. And it addressed a number of the shortcomings I referred to in the alternate dispute resolution program. It provided for private, confidential, in-person hearings, and it included a process in which the parties, including the AFN and the Inuit and claimant lawyers, got to select their adjudicators. It included a common experience payment, which designated $1.9 billion to provide compensation for all surviving former residents. It was based on $10,000 for attending a school and $3,000 for every year and above that. But it was important because it was the first time that compensation was awarded for the collective experience of all who had lived in residential schools. Then the Truth and Reconciliation Commission was formed to create and compile the historical record and promote awareness, with $72 million in funding and activities that are well known and applauded. There was there was a 5-year endowment for the Aboriginal Healing Foundation of $125 million. And fifthly, there was a $20 million fund set aside for national and community commemoration activities. So all of this happened. It was an unheard of type of settlement. It was implemented after court hearings in September of 2007. The court needed enough time to let people opt out if they chose to. Very few did. And ultimately, the IEP was implemented in September of 2007. And then there was 5 years for people to apply for compensation. There were 12,500 claims anticipated. There's no living soul that I know of that will claim responsibility for this number. In actual fact, the number of claims that we received was over 38,200. And this is really important context because it certainly leaves room for legitimate debate as to whether, if the parties had known then what they know now, they would have chosen a different type of compensation system. Still, if the agreement had not survived, like the rest of the Kelowna Accord, had not survived the change in government in November 2005, it's reasonable to conclude that it would have been years before any other type of compensation program would have taken place. So given the urgency of the problem, the scope of it, and the aging population of survivors, that was simply not an option. Sorry, but I hope that background sets the stage a little bit for what comes.
Yes, I think that most people are very aware of the Truth and Reconciliation work and the Commission and Senator Sinclair, but very few people are aware of the other responses to the class action lawsuit, and that's why we're having this talk about all of the other elements. So you have an entire separate from Truth and Reconciliation, linked but separate system in which adjudicators were selected and trained to go and gather testimony that were sensitive to trauma, that were trained for consistency. How did you do that? How did you choose adjudicators? My first question is, how were adjudicators chosen and trained? And I'll ask, how were all of the claimants assembled for the adjudicators to speak with?
Sure. Well, the adjudicators were selected not by the Adjudication Secretariat or Chief Adjudicator, but by the stakeholders, as represented by, there was an oversight committee consisting of the Assembly of First Nation representative, Inuit representative, 2 representatives of claimant organizations, 2 representatives of government, and 2 representatives of church. So they were the ones that they came up with and designed the National Competitive Request for Proposal program with criteria for adjudicators. They screened the applicants, they interviewed, there was representation from the Secretariat at the interviews, but we were non-voters. It was the stakeholders that were the voters, and it was by unanimous vote that any adjudicator got appointed. And this was really important in terms of the historic distrust of Western legal systems among survivors. They did not choose to have the court decide their claims. It was important that they therefore have input and have their agreement required for appointment of adjudicators. And then as the numbers of claims climbed, we had a number of other requests for proposals to ensure we had adequate adjudicator capacity, and we had distribution of female and male adjudicators, Indigenous adjudicators, and French language capacity. So
how many adjudicators were assembled? This is a heroic task of assembly.
Well, it was really quite something. It was over 100 adjudicators, as well as 8 deputy chief adjudicators and chief adjudicator at our peak. So that was really quite an undertaking to assemble this group. And I know you'll have some questions about how the adjudicators were trained and so forth, but in putting together the group and continuing to recruit and retain new adjudicators was a major undertaking.
And as I understand it from you, the adjudicators traveled. And this was a requirement of the job. The claimants did not come to the adjudicators. You were describing to me how the adjudicators went to the claimants, which is very novel.
That was also a big part of it. You know, again, part of historic distrust of Western legal systems. The courthouse is not exactly the best symbol for that. And so, and the idea of going to a courtroom and the judge would sit on high and so forth was not something that was thought to be appropriate here. And I think just to send the message to survivors that we'll go to you if you want. And in some cases, they chose, their communities were so small, they didn't want to see an entourage of adjudicator and government lawyers and church lawyers and so forth showing up. So they chose to leave their community and they would travel to another center. But in many cases, we would go to them and we would hold the hearing at their home. It could be in a nursing home. It could be at a lawyer's boardroom. It could be in a correctional facility, but we would go to them. And that was a really important first message. And I do recall many survivors telling me that they never thought that they were important enough, that someone would come and a group would come to hear their experiences. And this was an important step to take. And the parties chose in-person hearings. They didn't choose telephone hearings. There was no such thing as video hearings in those days. They could have had a written hearing kind of process. They chose in-person hearings. And so that's...
Danny, I have a question. Just at what date did that form of gathering of testimony start? Was that 2007, 2008, where the adjudicators were sent out to gather testimony?
Well, with the Alternative Dispute Resolution Program, that was continuing after the IAP was implemented. And so we are continuing with hearings in ADR, finishing those, even as the IAP had already formed. The IAP was slow getting off the ground because I think there may have been some uncertainty as to the take-up rate for it or the opt-out rate. And also because of government staffing and procurement programs, which took a long time. So I would think that the first hearing happened in early 2018 or 2008, I should say.
2008, yeah. So my next question, and I think I can return to the question of how people were trained to have consistency of decisions, what factors were involved. But I'm also very curious about how were the claimants assembled And I think you have a very horrible story to tell about how the claimants were re-victimized or victimized by predatory lawyers or law firms. You know, how you went to war, I think, against unscrupulous practices. So how did the claimants come to fill out the forms and come to your attention, and then the adjudicators were sent out?
Well, first of all, I wouldn't want to leave the impression, although we certainly had major issues with a small number of lawyers, the very vast majority of them were fine, ethical, professional lawyers. In fact, some of the best I've ever worked with. But for reasons that I never really understood, the larger national firms or even larger regional firms very rarely got involved in our work, and it tended to be sole practitioners that were not well supported, maybe not very experienced. There were a small number of those that created tremendous challenges for us. And I wouldn't say it by any means it defines our process, but it did illustrate some of the measures we had to take that were unusual for a tribunal, because we got into direct legal conflict with claimant lawyers who appeared before our adjudicators and before me on a regular basis. But what happened was adjudicators were given authority not by the settlement agreement, but by the courts when they approved it, to review and approve legal fees in every case. So, and if the fees were found to be not fair and reasonable, we were given authority to reduce them. The government contributed 15% of the compensation award towards legal fees, and the court put a cap on legal fees at another 15%, so in total of 30%. So there could be up to 15% payable by claimants. So when we started to do these fee reviews, in a handful of cases, our adjudicators had this unique position of being on the ground. They had to meet with the lawyer and the claimant afterwards, and they would find out things. In one case, they would find out by many of the claimants that an Alberta lawyer who had an absolutely massive practice, he was a corporate lawyer, but he got into the IAP and ended up representing 4,700 survivors and earning multi-millions of dollars. But it turns out that it was clear that he spent very little time with the survivors, contracted out much of the work to form-filling firms who were left unsupervised. And the lawyers would normally meet with the claimants not until right before the hearing started, which is far below the standards of practicing lawyers, far below anything a lawyer would be expected to do, even the most straightforward small claims trial, much less a serious case involving potentially hundreds of thousands of dollars and certainly huge emotional baggage for the survivors. So ultimately, his practices led to his removal by the court from the IAP, and he was ultimately disbarred by the Alberta Law Society. We had a few other examples. There was a Winnipeg lawyer who failed to comply with our adjudicator's orders to return $1 million in legal fees to survivors. He ended up getting disbarred as well. And thankfully, all of those fees were ultimately returned to survivors. There was a BC lawyer who amazingly hired a convicted murderer as a form filler. And there were allegations that this form filler extorted some survivors once their settlement checks arrived. We tried unsuccessfully more than once to have him removed from the IAP. There was a Saskatchewan lawyer who refused to provide an adjudicator with his fee agreement with his client, even though the court orders required it. He drew one up at the hearing on a piece of toilet paper and threw it at the adjudicator, who was a young Indigenous female adjudicator who found this very shocking. There was a case in Manitoba that's become known as the Manitoba form fillers case. And that was one where it came to our adjudicators' attention that in addition to paying their lawyers 15% for legal fees, some lawyers had affiliated themselves with form filling agencies who charge another 15%. And this practice really subverted our legal fee review process because the lawyers didn't produce the form filler contracts. And so our adjudicators were missing the complete picture of what people were paying. And they weren't sure because it was confusing for them. Were they paying one? They didn't think they were necessarily paying two sets of fees. So we were left in a difficult situation. There didn't seem to be anyone else to do it. And we ended up bringing a case before the Manitoba supervising judge for direction to put an end to this practice. And the court directed us to put forward a test case or a pilot case. And we found two survivors that came forward, one of which was a very ill woman from northwestern Ontario, a long ways away from Winnipeg. And she was receiving cancer treatment. When her settlement check came in, the law firm sent her a bus ticket to travel to Winnipeg to collect her check in person. And she was in no position to travel, but she did. And at great discomfort, she ended up going to the law office, and from there was actually followed to the bank by two workers from the form filling agency so they could get their cut. And the woman was not, according to the judge who decided the case, she was not sure what was going on and too afraid to complain or object. Ultimately, the court agreed that form filling agencies were not allowed to charge contingency fees. He ruled those agreements unconscionable and void. So we ended up putting in, my predecessor, Chief Adjudicator Dan Esch, and I put in expectations of legal practice in the IAP in an effort to put a stop to improper and exploitative practices. Because we ended up getting in conflict both with Canada and claimant counsel over this. Canada was, they had a successful investigation against the Alberta lawyer I referred to, leading to his removal and disbarment, but it cost a lot of money. And Canada seemed unwilling after that to support incurring further investigations of lawyers. And ultimately, the courts appointed an independent advisor to deal with those complaints. So as chief adjudicator, I didn't have to. But still, you know, it would have made very good sense to have a process in place like that right at the beginning, or better yet, an absolute cap on legal fees. So maybe the government contribution might be capped at 20% rather than 15%, but no further fees would have been payable by claimants. And that would have solved the problem. Other options might have been a legal aid type of system. But the reason I
raise this for people is as we move forward, and you'll see a little bit later when I ask Daniel questions about what's going to happen with future class actions, the learning from this process is really critical to build into process improvement for the next time. For Daniel, for you to be so involved in kind of policing behaviors of people that the system was counting on.
Well, it was certainly not a role that anyone anticipated that the Secretariat or Chief Adjudicator would play. And it was not something that I ever wanted or would have dreamt of, actually. When these things came about, it was shocking. And if there had been a better alternative, it would have been taken. But there just wasn't. And for the integrity of the process, to sit by and do nothing was a non-option.
So I presume that people filled out forms, the adjudicators went to them. We know a little bit about how the system worked. What were some of the minimum and maximum settlements? How you know, in the law, when people are in car accidents or they lose their income or something, there are tests on, you know, an arm is worth this much, something else is worth that much. How do you actually assess the degree of trauma? What were some of the tacit rules on how to settle awards and, you know, maximum, minimum, and average settlements?
There was a grid that was included in the IAP, the grid had a point system based on different varieties of abuse, with minor, or what order I don't think there is necessarily any minor form of sexual abuse, but the less serious sexual abuse being at the lower end of the grid, and the more serious forms being at the upper end of the grid. So, a case involving fondling would receive, the lower end of the level 1, and the highest level would be reserved for cases of repeated persistent rapes. And the same type of grid was put into place to determine emotional harms, where there were levels of harms that were available based on how serious the repercussions were. And at certain levels, at the higher levels, unless Canada agreed, claimants would have to go for an expert assessment by a psychologist or a psychiatrist to establish those levels of harms. With opportunity loss, that was also, there was a grid. So if you had difficulty concentrating, that would be at the low end of the range. If you had chronic inability to retain employment or obtain employment, those would be at the high end of the range. And so at the end of the day, the adjudicator assigned the points within the range, and then there was a certain amount of discretion within each range where an adjudicator could bump an award up as long as it stayed within that range. And that's how awards were arrived at. The minimum award in the IEP was $7,200, and compensation could be awarded up to $275,000 based on the nature of the abuse and the level of harm and opportunity loss suffered by each survivor. So in addition, there was compensation of up to $250,000 that could be awarded by adjudicators for actual income loss. And survivors seeking more than $250,000 in actual income loss could access the courts. So in the end, there was an average award of $91,500. And in total, there was over $3.233 billion paid in compensation to over 28,000 survivors.
And Daniel, you told me that at the beginning it was open-ended, that there was no notion of how much this was going to cost. And you said until the last survivor was heard. Shocking that so many survivors came forward, shocking the extent of the work.
It probably shouldn't have been surprising that so many came forward, because there were 80,000 survivors at the time of the settlement agreement. And at the end of the day, close to 50% of them filed abuse claims under the IEP. And I don't think it should have been a big surprise that this would happen, but it certainly was not part of the establishment of our tribunal or the anticipation. And there was no budget for the program. It was, as you say, until the last claim is resolved. And I think, as we'll hear shortly, that's something that the government of Canada will never agree to again. They will prefer a fixed amount, but that is what happened, and that's what the parties negotiated. They wanted in-person hearings. They wanted people to be heard, and that's what it ended up. It ended up taking much longer than anyone anticipated, but that was just because the numbers were more than triple what were anticipated.
I have a supplementary question that is arising from our elder at our university, who did workshops for Residential School Resolution Canada on, I'll sort of translate into Daphne speak, the vicarious trauma or the compassion fatigue of the adjudicators themselves. So I'm wondering, and I've heard through word of mouth that some of the labor arbitrators were a little bit more hardened. Some of the people from the community who really felt the suffering really were traumatized by it. Was there post-traumatic stress by the people that were hired to be adjudicators? And how are they today?
Well, there are a lot of us, and I keep in touch with some, but by no means all of my former colleagues. And I would say that it was a certainty that adjudicators did suffer from vicarious trauma or secondary trauma. And we did try to prepare them as best we could. And the ways that we did that, and it changed as we evolved, but we had traditional sort of Western sessions on vicarious trauma workshops that we had delivered across the country to our adjudicators. We were originally told we didn't have a budget for it, that adjudicators needed to bring their own mental health to the hearings, and that was their own responsibility. And that was obviously not something that we ever accepted. We also involved elders in all of our training programs. And we developed a system where adjudicators would check in on one another and often meet in small groups in their communities where they were able to once a month have lunch or share coffee, because you couldn't talk, all these hearings were confidential. You couldn't talk about this to anyone except other adjudicators. So undoubtedly, people did suffer from this. We had a number of Indigenous adjudicators. A number of them were survivors themselves. And so I cannot imagine what it was like for them to preside over hearings. I know that for many of them it was difficult, and very, very difficult. And so we needed to work with them to find out what the healthiest way was for them to proceed, whether spacing apart their hearings or giving them additional support of a reader of their decisions. Whatever it was that was needed, try to identify if there were issues and how we could help with that. A number of our adjudicators have interestingly gone on to, our Indigenous adjudicators have developed training programs, particularly in Western Canada, around trauma-informed adjudication. And that was, of course, the result of their experience with the residential school program. So we had sessions on healthcare. We had one of our training sessions, a national meeting of adjudicators. For 3 days, we had a healing lodge set up in the hotel basement, or the basement of the hotel where we were having our meetings. And in the first day, it was the Indigenous adjudicators, a few of them going in. By the second day, the non-Indigenous adjudicators were flocking to it. By the third day, the Indigenous adjudicators couldn't even get in. And it was just one of those things that people found. We had a male and a female elder that would engage adjudicators in ceremony and brushing off ceremony and medicines, and it was really quite something. So, but having said all that, I know adjudicators ended up taking time away from work, distancing themselves from the work, and many of them needed psychological support.
And you said something to me earlier about when people testified and provided their experiences, that at the end someone apologized. Could you talk about the cathartic value of that? That was a major learning in my brain when you said it, and I'm hoping you can convey what that meant to people here.
Well, that was in every case, the government of Canada sent a representative and conveyed apologies. And as I forget what year it was, the Prime Minister Harper issued an official apology, and they offered then from that point written apologies to anyone who wanted them. Some would take an apology and burn it, some wouldn't want it, some would want it. But for those that invited Protestant church reps to attend, they had a whole different experience, because the Protestant churches, like their Catholic counterparts, were entitled to be there as defendants, to defend claims and oppose credibility and so forth, but chose not to. And instead, they chose to offer support where invited. Unfortunately, the lawyers did the invitations, and it didn't happen as often as it should have. But where it did, those were some of the most amazing hearings, where at the end of the day, there wasn't a dry eye in the room, and the church representatives and the government representatives were apologizing and offering support and bringing really personal, heartfelt words. And survivors would say they never dreamt that they would live to see the day that they would have a church rep and a government rep meeting with them to apologize. And so those were really fantastic hearings and profound. I think that really helped in terms of, because I think for many people, there are still conflicting loyalties. Many are still, they spent their whole childhood growing up in let's say in a Catholic school, and they're still Catholics and so forth. And yet they haven't had the sort of apology that they have been hoping for. And so there's a disconnect there that I think has really stood in the way of healing, whereas the Protestant churches have been just tremendous with their efforts in public and private apology and offering support and assistance.
So I think I'm going to skip directly to a question about the trauma of the survivors in providing testimony. Confidentiality issue. You had a heck of a battle on how to keep confidential, how traumatic it was for people to disclose fully and be cross-examined and have intrusive questions and have to answer fully and have it recorded for posterity in order to have decisions made. And then people who felt that though that historic record should be made public, well, your Secretariat made promises, or your IAP made promises of confidentiality that made people more comfortable in disclosing the damage that was done to them. So there were, all the ethical dilemmas, and you spoke about some involving lawyers. The battle that you were involved in about whether the record should be opened or sealed, which went all the way to the Supreme Court of Canada in 2016, was both an ethical, a legal, a moral. I mean, I can't imagine how difficult it was to get embroiled in the issue of the sealing or the unsealing of testimony. So could you tell us a little bit more about that situation, what you did, what you felt, and some of the outcomes for the survivors?
Okay, well, the element of confidentiality wasn't just promised by the Secretariat, it was promised by the settlement agreement. And in addition to that, at the start of every hearing, anyone who was in the hearing room was required to sign a confidentiality agreement. So it wasn't just adjudicators signing it, it was Canada signing it, any church reps, any translators, the claimant signed it. Everyone signed it. And the whole idea that was to put people at ease. We did have survivors showing up at hearings very, very distraught, to the point of, passing out and so forth, but fainting before their hearings and things like that. And so it was only with those reassurances that they would stay to tell their story, that they knew there was no danger of their story getting out to their family, to their community, to the public. That was the single biggest fear that they had. The shame that even though as adults they knew none of this was their fault, it was still the child inside them didn't necessarily come to that same conclusion. So what happened was there was a process to transfer materials into an archive, and claimants were to be given an option to transfer their transcripts into an archive that was to be developed. And the archive that ultimately was developed was the National Center for Truth and Reconciliation in Winnipeg. But it wasn't developed until, I forget what year it was, but I'm thinking it's around 2014, well into the settlement agreement. And so we were unable, our adjudicators were unable to tell people where was it going to go, under what terms of use, who would have access to it, what restrictions would be put upon its circulation. And so we ended up, the oversight committee of our process met with the Truth and Reconciliation Commission over an extended period to try to negotiate a consent form to the release of information. But those discussions broke down. I think the TRC withdrew from them when they realized that if survivors had the opportunity to say yes, that meant they also had the right to say no. And so the TRC, which was our sister tribunal, had up until then fought Canada constantly in the courts, abruptly withdrew from these negotiations, changed positions, and for the first and only time that I know of, joined forces with Canada to seek compulsory transfer of every IAP file into public archives, even where claimants were adamantly opposed to this. So this came quite late in the day. I was already chief adjudicator, so it was 2013. And it was a deeply troubling turn of events. We had made those promises, our adjudicators did, I did in hundreds of cases. And, you know, one option would have been, let's just, you know, let the court decide and not take a position on it. But I didn't think, even though it's uncomfortable for a neutral tribunal to take a position on this issue, having made those promises myself and having asked my adjudicators to, I didn't think it was an answer to say I was going to remain neutral. I was neutral as to what claimants chose to do with their files, 100%. But I was not neutral on a promise that was made. Ultimately, Canada and the TRC showed up in court and said confidentiality really only meant confidentiality within the meaning of the suite of Canada's privacy and access legislation, so which meant that claim files would be made open to the public so many years after death. So anyway, this was traumatic for survivors. The litigation played out over 5 years, and there was a tremendous amount of uncertainty for survivors as to what was going to happen with their records, where we could no longer assure them of confidentiality in light of the position that the government and the TRC were both taking. And so we needed to wait until the Supreme Court of Canada decision. The Supreme Court gave people until September 10th, 2027 to decide if their records will be destroyed or archived. And if they don't make a decision, then they get destroyed. If they get archived, they go to the National Center for Truth and Reconciliation in Winnipeg. And there's just 4 kinds of records that are still kept. Those are application forms, adjudicator decisions, hearing transcripts, and audio recordings of hearings. Those are still there and will be there until September of 2027.
So let's just presume that everything was confidential. Once they were advised of their right to have their materials transferred, what percentage of the people who testified to the IAP actually granted the right? All of them offered the ability to have the transfer.
Yes, and the court directed a very robust notice program, a multi-million-dollar notice program for people across the country by social media, by radio, by television, by band office, by community office, posters and notices. And it was a massive undertaking. And after all that has been said and done, I'm maybe 6 months or a year out of date in terms of the data, but when I was last chief adjudicator, the number of claimants that I believe had requested that their records be archived with the National Center was somewhere between 25 and 30. And so it could be—
Wait a minute. Between 25 and 30% or people?
People.
20.
And again, one can understand when the case went to the Supreme Court of Canada and the lower courts before that, many survivors came forward, including Phil Fontaine, And he filed an affidavit saying, I don't care whether it's 25, 50, or 100 years after my death. I don't want to burden my descendants with what happened to me. And so it's very well for historians and others to say, well, this should be all public and so forth. But given the deeply personal nature of these experiences, and not just the abuse that people experience, but the harms that often involve serious interpersonal issues with their family, it should come as no surprise that people don't want that to be circulating in public. Now, there are restrictions in place. People could put restrictions on it with the center if they choose. And also, people are at different stages in their healing journeys, and maybe by the whole idea of this cooling off period is to give people an opportunity for reflection. And maybe by at some point between now and 2027, they'll feel differently about it. But the other thing to remember, there were 7,000 people that gave statements to the TRC.
That's exactly what I was going to ask you. Are you able to, at least in your own mind, compare the public statements of people who went before the TRC and knew that they were speaking out publicly? Were the same people testifying in closed, sealed, is the information the same, or did they disclose more differently? How do you compare?
That's very difficult for me to compare, because I don't even know it was in all of the tens of thousands of transcripts, much less what they testified to with the TRC. But certainly many of the survivors were the same, who came public. That was the whole idea. The TRC was to be the public side of the settlement agreement. The IAP was to be the private reparations side of it. They were not one and the same. And the TRC seemed to treat them as one and the same, but that's not what the parties agreed to. But they did have 7,000 statements, and people might be, and probably were, much more general. I'm not saying they said one thing to adjudicators and another thing to the TRC, but I think it's fair to assume they would have been much more general and maybe less personal, much less detail perhaps in a public setting than they were in our hearings.
I'm just monitoring the chat or the question and answer to make sure that I've kind of hit on some of the items. What I want to go back now to the scope of your the size of the IAP, how big, how many employees, what was your budget? How did you pop up and then close down? This is a massive undertaking to open, train everybody, staff up, and then basically stop. So can you give us an idea of the scope of building an organization and then disbanding the organization?
Well, I think you could refer to it as building an airplane while you're flying. That's what we were doing. We started off very slowly because of the issues I mentioned, with concerns about opt-outs and procurement and staffing requirements. The government staffing, the people that worked for our secretariat, I will say, were fantastic and very dedicated. Civil servants that were really committed to the work. It took a long time to get them in place, and it took some time to get. There was a request for proposals first for a chief adjudicator. The first one was Dan Ish. Then there was a request for proposals for deputy chief adjudicators, of which I was one. And then the deputy chief adjudicators and the chief helped the stakeholders work with the stakeholders to select the adjudicators. All of them needed separate requests for proposal processes. And as you can imagine, those are not known for moving along very, very quickly. But in the end, we ended up with 4 offices in Gatineau, Winnipeg, Vancouver, and our head office is in Regina. And there may be some argument that this was appropriate entirely because Saskatchewan was the epicenter of the failed residential school experience based on the number of survivors that lived here. We at its peak, we had 275 staff in those 4 offices. And then I mentioned 109 adjudicators. It was very challenging to get ramped up, but we got there. And once we got going, and our budgets initially were quite small, the budgets ramped up as our work ramped up. During the peak years, we were handling 4,500 hearings a year. And those were in-person hearings, some of them in remote communities in every corner of the country. And our staff was probably running the biggest travel agency in the country. And they were organizing and paying for travel of claimants, supporters, elders, translators, adjudicators. It was a tremendous logistical undertaking, and they became very, very skilled at it. So in our peak year, which is 2013 and 14, our budget was 60.5 million. In that same year, the compensation awarded was 452 million. So administration that year amounted to 13.4% of compensation to survivors. And in addition, Canada had its own costs for research and its own people for travel and representation at hearings. The data for this is laid out in full detail in what's called the IAP final report. If anyone is interested in that level of detail, the IAP final report is on our website, which is still in place, although it's frozen in time from when we closed our doors on March 31st last year. And the website is iap-pei.ca. And if they go to the IAP final report, all of that data is on page 60.
I have, Susan is asking a question, which I think you're in the process of answering, about general comments on how to train for and engage in trauma-informed adjudication. Is this something that is transferable to other settings? What about to labor arbitration? What about the criminal justice system?
100%. 100%. Our former adjudicators who are now really sort of taking this area by storm, they are reaching out to, I mean, there are judges that are reaching out to them. There are law firms, large law firms that are reaching out to them, corporations, educational organization, advanced education. And so, and they do sessions that are maybe an hour and a half long that are, you know, they're not necessarily the ending point, but they are a starting point for someone that is interested in a trauma-informed process.
So going on to, what do you think is the likelihood of the proposed First Nations child welfare class action suit succeeding? Some of the 60s group litigants. Are you anticipating more class action and more creation of reparations programs?
Well, if we look at what's happened since the settlement agreement itself, there's been a number of, as you point out, class action settlements. The first sort of smaller one was in 2016 in Labrador, where I think it was 4 schools that were left out of the settlement agreement had their own settlement. And this was quite different in the sense that Canada paid a fixed amount towards the settlement of all claims for the students, and then left it to the class members to sort out the distribution of funds. They used a simplified grid. They made it clear that there was no access to the courts. We had many of our claims that ended up going to the courts. But they said no courts, no reviews, no Canada in there disputing it afterwards. And this was, let's call it a check writing exercise, because this was the first of many that would follow and that will follow. Where Canada wants to avoid, I'm not speaking for them, but I think it's fair to surmise, they want to avoid another TRC, and they want to avoid another IAP because of the uncertainty of the costs And certainly in the TRC, the uncertainty of the cost, that's still an ongoing obligation of the government that's yet to be met and no one can really put a dollar figure on it. So they don't want that anymore. If they pay too much, the survivors get to split the excess among them. If they pay too little, the survivors take a proportionally reduced amount. But that small template, it had a very simplified grid. If you claimed this abuse and these harms, you got this dollar. And so that was used in the other settlements that follow. You mentioned the 60 scoop and the federal Indian day schools, neither of which, of course, had anything to do with us, with our agreement. But they had a very similar concept, and those were approved in 2018 as far as the 60 scoop. That was August 2018. 2019, August 2019, the court approved the day schools class action settlement. So the other factors that are key to all these, there are presumptions of credibility of survivors. The cases are dealt with primarily administratively, not through adjudicative processes. No access to the courts. And again, a conspicuous absence of truth commissions. So their benefits to Canada are clear. Once they've written the check, they're out of the equation. And I can also see there is some logic in terms of avoiding the cognitive dissonance of Canada trying to promote reconciliation on one hand while staying on in an adversarial role in another. So, Canada benefits by avoiding further truth commissions. The benefits to survivors are it's fast, it's expeditious, and undoubtedly, especially with an aging population, it's an important element of justice. There's no risk of people being triggered at a hearing or facing a credibility challenge. There's no hearings. All legal fees are paid by Canada up front. There's no payments required by survivors, no risk of financial exploitation. So, I mean, survivors can speak for themselves on this, but looking at it from the outside, those would seem to be obvious. So the question that has to be asked, and with the child welfare tentative settlement, it has to be approved yet by the court. It's not just class actions that are being settled, but also a huge obligation placed on the government by the Canadian Human Rights Tribunal. It's all been wrapped up into one package, and it's difficult to know exactly what it'll look like. But as we've seen these other settlements unfold, we have a pretty good idea that it's not going to be individual hearings, and further, there won't be public hearings. So it's going to be a check writing exercise, and it'll be for survivors of the child welfare litigation and human rights hearing. And they are in the best position to decide based on the types of wrongs committed, the scope, the nature of their group, their demographics, their ages, their needs, and their wishes. Do some survivors value the opportunity to share their experiences with a neutral person, a neutral adjudicator? Is validation of a claim important for some survivors? Is receiving an in-person apology from a government representative, or in our case, church representative, important for some survivors? And is there a concern that people are missing the lost opportunity to speak and create a public record of what happened is absent? So maybe that will ultimately form part of the next settlement. That I don't know yet.
Can you just end with number one, what you look back and see the contribution you made in this process? And then if people want to read something or look up or go into their wormholes and verify and examine and learn more, because I started by saying this would cause both anguish and an appetite to know more. how do you feel about yourself, and what would you recommend people do as next steps?
Well, again, for me, the most important part of the work and the most memorable work that I'll carry with me for a lifetime will be the survivors that I met and worked with. And all of the rest of it, the legal problems, the court challenges, the conflict of interest considerations we faced, they pale, and what we went through pale compared to what these courageous people experienced earlier in their lives. And so that was really something that I will always take with me, that I was always greeted with warmth and often with humor, despite very, very trying circumstances. And people are really quite amazing. Many of them deeply damaged, but many resilient and refusing to define themselves by what they went through, and living in the present and not in the past. So I really think it's I would not have been part of a process that I thought was traumatizing people if I didn't see firsthand the hugs at the end of the hearing that were very common, the tears at the end, the relief, the people expressing like a cloud had been lifted from them. If I didn't experience that myself over and over and over again, I wouldn't have stayed with the process. I found that was a key part of it, and that's something that didn't happen in any other kind of a legal or restitution process that I've ever been involved in. So I don't really want to comment on what kind of a job we did. I think that really is for others to assess. But what I will say is that it is inevitable that there will be other mass tort claims that will be brought forward in the Indigenous world and perhaps in other institutional settings. So I think there's as long as people are vulnerable, and Akiva Starkman, who was our former executive, wrote about this. He said, when vulnerable people are placed in an institutional setting without any personal power or without someone to speak for them or protect them, there is a high risk they will be victimized. The experience of residential schools was in many ways exceptional in scale and scope, affecting as it has generations of Indigenous people. But the examples of institutional abuse are legion and unfortunately ongoing. Therefore, it's important to not only provide reparations for the residential school experience, but to learn from it, to protect the vulnerable, to accept diversity, to resist institutional pressures for conformity, to guard against imbalances for social power, and to be skeptical of demands to cede voice and independence and freedoms. So that's a long shopping list, but if we came anywhere close, and if I had any role in achieving anywhere close to that, then I will be content.
Daniel, Akiva, I think is on this call listening to you, so I'm sure he's happy to see his thoughts recognized. But what I want to say to you at the end comes actually from Joanne Dallaire, our elder, directly her words. Mr. Shapiro, my deepest gratitude for your difficult work. Thank you for coming. Thank you for being with us. I hope that we're able to preserve this transcript so that some of our students and academics and community members will be able to listen to it and learn from it. And it's just been miraculous having you with me. Thank you.
Thank you so much. And thank you so
All of
much
us.
to Elder Dallaire, is it?
Yes, Joanne Dallaire.
Joanne, thank you so much. It means a great deal to me, and I'm sure to others, that you're here with us today. It's so important. So you honor us with your presence.
And I would like to thank Enthusia and Isaiah for helping set up the Dean Speaker Series and doing all the testing of the equipment and making sure we were adequately lighted. And I really would like to say that we've had a traumatic and difficult conversation involving truths that were verified, and people should leave here with an appetite to learn more and more and more and reflect on their responsibilities for reconciliation.
Thank you, Daphne. I'll just mention, you had asked about other reading.
A
If
book.
people
Mhm.
are interested in deepening their reading, there's an amazing textbook by University of Saskatchewan history professor by the name of Jim Miller, and it's called Shingwak's Vision. And it was written probably close to 20 years ago, but it is the authoritative work on the history of residential schools, and it is very worthwhile for anyone who chooses to get that sort of level of detail.
Thank you. I'm going to look it up and get it, and I hope everybody else will as well. So
Thank you, everyone, for joining us, and have a safe evening and a good evening. Thank you, Daphne.
bye-bye, everyone.